As I said, Karim, the lecture starts at 10:15. Thank you for opening the camera. That's very helpful. So we have 10:15, the usual time for starting. I'm Thomas Hoeren. I'm the person who has organized the whole stuff. Let me start with some organization matters. Unfortunately, the direct connection between Zoom and YouTube doesn't work today. It's always a miracle what happens with this direct connection between Zoom and YouTube. Sometimes it works perfectly, sometimes it doesn't work at all. It doesn't matter. I will use my copy, which I made via Zoom, and put that copy after lecture on Zoom, on YouTube. So you need to wait for 2 hours for me to do upload the video on YouTube, but then it's all there. No problem at all. Second organization matter, we will send around a link for a Q&A session because next week is foreseen after the lecture that we have a Q&A session here. So please stay in the lecture after next week's lecture and wait for Q&A. There's a session where you can ask all your questions, whatever it is. You can ask silly questions, stupid, nonsense questions, whatever you want. Everything will be answered. Next week, we'll have Guido Westkamp here. He is a professor from London. He is just staying in Münster, around the corner. He will come and give a lecture on copyright law, the acquis communautaire. I will explain you within 5 minutes what that is. So, guest lecture next week, and after that, we have Q&A, questions and answers. Do you have urgent questions? Even here, you can ask urgent questions, organization questions. No, something. Perhaps you wonder about my voice. It sounds like Tom Waits singing. I've made an anti-flu treatment, and the reaction of my body was to have flu. So it's a mystery what happens, but nevertheless, the sound is like it is. So you have to get used to my voice. Somebody asked, is the schedule of lectures changed? No, we will stay in the habit of Tuesday, 10:15, having lectures. It's only having a guest next week for 45 minutes presentation. So I hope that answers your questions. So let me summarize what we did during the two last lectures. I've made a statement that we start at the point to say information wants to be free. So that is an overall statement which helps to structure all my lectures. Because then, of course, any system of intellectual property right needs to be justified, and it is not allowed that it violates this overall freedom of information. We've seen that there is one exception. It's a minor exception, not a general one. It's trade secret. It gives kind of mini intellectual property right for trade secret, whatever trade secret means. So today we start at a second issue, the topic of information society, copyright law. And I start with my slides, which you have all got. So let me start with that one. So let me start with the first one. So copyright law, an introduction. First, the question is, what is copyright law about? Because we have various regimes of protecting information. We have a protection of science. Look at your trouser. You will find on your trouser certain marks here, signs, saying it belongs to Levi's and others. It's trademark protection. We have protection of the invention. That's techie, the technical people who are inventing technical new things. That's patent law. We have a protection of design. For instance, marvelous design of my glass. Very beautiful shape, opening here, broadening here. It's so incredibly beautiful that you get a design protection by the Design Patent Act. And then we have a protection of creativity, and that is copyright law. And if nothing helps, that's a feature in European and American law. We have a supplementary protection under unfair trade laws, UWG. That might be as well applied supplementary apart from trademark law and patent law. I've used two examples to explain you the borderline between copyright law and the other systems. Does anybody of you here in the room know which is cheese, Hexenkäse? It's a very strange Hexenkäse which is sold on the border of the Netherlands. So only 50 kilometers from here, you can buy witch's cheese. It sounds terrible and is terrible. So because you smell a horror of smells, not very nice. But the owner of witch's cheese one day said, I want to get copyright. And apparently he was so rich that he can afford to go to the European Court of Justice and said, I want to get a copyright protection for the smell of witch's cheese. Can copyright law protect the smell of an object? Of course not. As I said, copyright law is only there for intellectual property creations. That means it has to attract the intellect, but not what do you smell. Take another example. Do you know where does this sentence come from? It's called Vorsprung durch Technik. It's even known in English-speaking countries. Yeah. There's a famous wording of Audi advertisement. They say always in the advertisement, Vorsprung durch Technik. And they had a feeling that should be protected by copyright law. Is it a topic for copyright law? Is so brilliant, is it so creative that you feel the power of creativity in the sentence? The ETJ, the European Court of Justice, said, wow, it has nothing to do with copyright law, but with, going back to that slide, how can you protect a word like Vorsprung durch Technik? It's not copyright law, but no, it sounds like trademark. But in order to get a trademark protection, you need to be known in public, because the words Vorsprung durch Technik belongs in general to everybody. Everybody can say Vorsprung durch Technik. So you need to see the word Vorsprung durch Technik and say, ah, that's Audi. Then you get a trademark protection. Here you see a very nice other pictures of what I said. Copyright law, our topic is a protection of literary, scientific, and artistic works. So you need to prove intellectual proper works, creations, cultural works. That is copyright law. But patent law is only invention. Trademark law is science, like Coca-Cola and the others. And that is called some little patent law rights, that is design law and utility models. Here you see one thing. Patent law can only be given to an object which is registered. So you need to go to the Deutsche Patent- und Markenamt or to the British Patent Office and ask for patent protection. Then you get a 20 years protection. But you need, there's an officer checking the invention. Is it really an invention? Trademark law can be given on registration. You have to go to the Deutsche Patent- und Markenamt or to the British Patent Office, ask for trademark protection, or you are so known, like Vorsprung durch Technik, that people say that is Audi. Then you have a trademark protection. The advantage of copyright law is there's no formal act. So you can say, I don't like Deutsche Patent- und Markenamt. I don't like an officer to check my creation. I simply get it because I'm creative. And how long do you get a protection? That is 70 years after the death of the author. That's a very, very long protection. So it's cheap and it's long, but that needs to be justified because it destroys the freedom of information. So let us go simply to the history of copyright law. It's a typical topic of German law professors, which always start with history. What can you find in Greece or in Rome? Nothing, nothing. What can you find in Middle Ages time? Nothing. Sometimes you find in the books a curse. If somebody dares to copy my book, he will be held in hell and remain in hell forever. That's the first thinking of punishing plagiators. So the starting point for copyright law is very strange, is Gutenberg. Because Gutenberg made a very nice invention. It's an invention not under patent law, but this invention leads to the widespread of copyright. He invented the idea to publish a book, to make books. And that was starting point for a generation of printers. It started in Florence and Venice. There were the first printers who said, hey, hello, it takes me 2 years to publish a book, to print it. And it's very strange if somebody is daring to copy my printed book. The protection of the printers. And you feel the printers and their influence in the word copyright. It's a protection against copying of books. In Florence and Venice, they went to the Doge, to the Prince of Florence and Venice, and asked for a special protection for their printing process. And they got it. They got a letter of the Doge saying, if you have printed that book, you are the only one in Florence or Venice. That leads to another principle, which is still in valid today, the famous territoriality in copyright law. We don't have a worldwide copyright. That's a feeling Hollywood always wanted to get. Please protect our films throughout the world. If you make one film, we need a protection in every part of the universe. No, that's impossible. Copyright is only granted as a privilege on a certain territory. And that is extended by the courts to say the territory is a place where the copyright is used, the market principle. So if you are using a copyrighted material in Florence, you get a protection against that granted by the Doge, a privilege, a letter saying you are the only one to disseminate that information. So it was a printer privilege for individual printers. Imagine, we are not talking about authors. We are talking about printers. And there are no author's privileges. I had a very nice lady who has published and made her doctoral thesis here at the Institute, 1,700 pages of checking every privilege in Florence and Venice. A nice time for her. 2 years sitting in old libraries, checking what the Doge had said. He has never given an author's privilege, but only a printer's privilege. So that was the beginning of territoriality. And then the first lady came, one of the most ugliest lady in modern times, Queen Anne from United Kingdom. She was really ugly. Sorry to say that. But she had a lot of problems with the press. And what do politicians do when they have problems with press? They give gifts. And she said, all British princes should be protected by a general privilege. It's not a privilege granted for an individual printer, but for all British printers. That was the first law on copyright, the famous Queen Anne Statute from 1709. And that is very, very important now, because that was the beginning of two worlds in international copyright law. I love that slide. It's so remarkable because you can distinguish until now between New Europe and Old Europe. That was a famous distinction made by Rumsfeld, the famous US Ministry of External Affairs. He said there's New Europe, there's United Kingdom and USA, and there's Old Europe, that is France, Spain, Germany, and the others. And I would think of a task for the listeners in Zoom. Think of your own national copyright law. Perhaps you can distinguish whether your country is an old Europe country or a new Europe country. The new Europe people start in 1709. Queen Anne Statute. So, as I said, it's a protection of printers, or to say it in more general words, the investors, people investing, giving you the money for a certain technique. So it's a protection of investment, and the standard of creativity is very, very low. It's called, in English, called the sweat on the eyebrow. You only need to have sweat on the eyebrow, then you get protection until 70 years of the author, of the investor. So somebody investing in creativity, what does he want? He wants to have money. Money is the most important thing in copyright law. The money rights can, of course, be transferred to another person. You can say, I want to give another printer the right to print a book, to transfer the rights. And you can also give copyright to legal entities. You can say, you're a corporation, it's okay, you are the creator, the right holder. That is Great Britain. Then let us go to old Europe. The starting point there, it was 1789. One day, 2 years ago, I have to make an oral state exam, and I asked, what happened in 1789? You had 5 students sitting there and saying, oh, 1789, what is he asking? What happened in 17? Then somebody said first, suddenly, I know it. It was the beginning of the First World War. I said, that's incredible. It was, of course, the French Revolution and the famous Declaration of Human Rights. And there, as a sentence, droit d'auteur. We don't speak about copyright. We speak in old Europe countries about droit d'auteur. And you see the term. There is a protection of authors. For the first time, the author is coming in view. The author is not protected because he's investing money in the work, but because of originality. So you need a specific standard of creativity in order to get copyright. And this requirement is high. You need a very high standard of originality to be protected. You need to be Valin, Rimbaud, what else? Dumas, all these guys. And what does a French author wants to have? Does he want to have money? Of course not. He wants to be loved. He wants to be seen as an author. That's the most important thing. For if you get €2 in order to find a bottle of red wine, it's okay. But the most important is to get love. This love right we call droit moral. That's has nothing to do with moral rights in the sense of morality, but it's a protection of the personality of the author. Mr. Bush, the famous American president, went one day to a dinner and gave a lecture, and he said, I hate the Europeans because they are so moral in copyright law. It was totally rubbish. Moral rights means personality rights. And these personality rights can, of course, not be transferred to another person. And it cannot be given to legal entities, as such as corporation. So this distinction between two worlds is still existing today. So perhaps you check at home which what is happening in your country regarding old Europe and new Europe. But I know a lot of people from Great Britain who are going to Netherlands in order to produce films because they say this Netherlands is better for creators than UK. So, of course, one day a British citizen met a French people, and they need to say, what do we do with books and films and all this stuff? Because it's a problem with these two worlds. So they drafted bilateral treaties. For instance, the United States and Germany drafted in 1880 a treaty on copyright law. But then they decided we should meet everybody in a place which is so nasty, so boring, a depressive town where people like to kill themselves. It was called Bern in Switzerland. And there they discussed the future of international copyright. And the outcome in 1883 was the famous Bern Convention, today called Revised Bern Convention, RBC, because that is the standard of international protection. But again, if you are at a party and you didn't manage to go there, you miss the party, you miss anything. So in Bern, it was only a meeting of old Europe because Great Britain and United States were missing. So what they did in Bern was an international copyright treaty only governed by the principles of old Europe. Very important to understand. There you find droit moral, there you find the highest standard of originality, no protection for legal persons, and so on and so on. The United States came only on the international stage in Paris in 1952 with the Universal Copyright Convention. So in that other treaty, you find everything necessary for Britain and the United States. Then the USA decided to withdraw from UNESCO, the country responsible for the administration of the Universal Copyright Convention. It was a tragic decision. I was stagiaire at the time at UNESCO. We saw every morning people killing themselves in front of the building of the UNESCO because US decided we will leave the UNESCO. Why was that? Because they think Gaddafi was so important at UNESCO, is controlled by Marxists. And Ronald Reagan decided we have to leave. And they decided to have future discussion on international copyright law in WTO. So because they're not controlled by the Gaddafi and the others, so they made a special agreement on copyright law called TRIPS, Trade-Related Aspects of Intellectual Property Law. In the ABC and in TRIPS, you find similar principles. There's equal treatment of nationals, so a foreign creator should be given the same rights as the national creators. Every way of introducing reciprocity, that means of saying you only get the rights under our national law if you have the same rights in your country is forbidden. Then minimum rights, that means you can say, of course, Germans get the same rights under RBC in China as Chinese authors, but Chinese authors don't have any rights. So they could say that's the same. You get the same rights, nothing. So that's not allowed on a Bern. We have some minimum rights which should be given to foreign people. And the exception I won't talk about, TRIPS has one advantage. TRIPS said if you want to become a member of TRIPS, you need to adhere to the principle of RBC. So China, for instance, has never signed RBC, but has signed TRIPS, and as being a member of TRIPS, they need to stick to the principle of RBC. And now I'm coming to the point, the European copyright law. We made one big mistake in 1900, I think 75, 76. We let the British in. That was a terrible mistake, which was corrected several years ago. But then we had old Europe and new Europe within Europe. So who is winning in the game? So British or French? So we will discuss now two directives. That is software protection from 1991. This one was one of the earliest directives we ever made. And I will explain you the winner in this directive was Britain, because this directive totally influenced by British copyright law. Then we had another directive, the database directive from 1996. And there again, you see that the change is not only British, but also French. So you find both elements. Then we have a directive on the protection of the information society. Nothing happened there. And we have the same as a DSM directive, a topic of Mr. Westkamp. Now I will change my slide. So one moment. If you have any question, do not hesitate to ask. If you don't want to ask, I will start. Yeah. With that topic. The famous directive on the legal protection of computer programs, that is very important for digital society. I hate the term digitization because digitization suggests that we are still in the analog times and we are coming to a digital society in 10 years. We are already in the digital times. And we have already had digital times because we had software. Software has always been digital. So the first model to understand what happens in Europe in the digital society is the Software Protection Directive. So, I hope you had the time to print out the text. It's a rather short text. So it's my text. You can open it on laptops as well as make a printout. When you see the text, it says it's a directive of 2009. That's not true. The directive is from 1991, but it has been changed several times, and they made a consolidate version in 2009. So again, you have the same structure as in the trade secret directive. Some consideration as start, mentioning, of course, the competence norm in the treaty, Article 241, and then starting with whereas the recitals, the considerations which led to the directive. You will find only 20 recitals. It's rather short. If you take the AI regulation, you have more than 700 recitals. It's much longer. And it started, of course, with Article 1. The title is incorrect, and there's only one example of many mistakes in the directive. So the lady who is responsible for that directive is now the head of the travel agency in Brussels. So she has been dismissed. So it said the directive on the legal protection is totally incorrect because it has only to do with copyright law. So no reasoning about patent law for software, no reasoning on trademark law. So only a specific copyright protection for soft goods. This directive does not protect ideas. That mentions in Article 1, subsection 2, ideas and principles are not protected by copyright law under this directive. Die Gedanken sind frei, wer kann sie erraten? A wonderful German folk song, which has the feeling thoughts are free. Information wants to be free. Here has the starting point. That's the general feeling. If we don't protect ideas, that is also true for other things which are similar to ideas. For instance, algorithms. We have considered already trademark protection, trade secret protection of algorithms. Algorithms are the mathematical logic of a program. So if you have a logic like a quadrat plus b quadrat, that logic, a quadrat, b square, c square, that sounds very, very impressive, but it is not protected, of course, by copyright law. 70 years after the death protection would lead to a monopoly in mathematical logic. So it's impossible. But the problem in the AI world is much more complicated algorithms are mentioned if you use ChatGPT or other product of the AI world. So it's an open question, what is happening with the complex mathematical models integrated in ChatGPT? Three is also interface. Do you know an interface? It's a mini software which helps in order to let a computer speak to a printer. Have you ever managed to combine your computer with a printer? It's a horrible problem. It never talks to each other. And the mini program of interface helps that a computer can understand a printer. But if you have copyright in an interface, you have the power. That is shown in the case of 2007, Microsoft against the Commission. That's a typical problem of antitrust law. If you have the copyright law in an interface, you have the power to regulate the whole hardware industry. So the Commission said, we don't want Microsoft or IBM control the world. We simply say an interface is not protected by copyright law. Then programming language. Of course, if you are the creator of Python or of Quick Basic, you can control the world. You have the sign of euros in your eyes and say, I want to have money. That is impossible. That is the reason why the ECJ, the European Court of Justice, said no monopolies in programming language, no protection. And the same applies for software functionalities. Everything which is technically functional in a program cannot be controlled by a copyright that is forbidden by the ECJ. And very important, dictated by necessity says, imagine you are running around in Hamburg and you see a software for accounting, financial data. And you see it has a structure, a design. When you open it, on the left hand, activa, active, right side, passive. You say, wow, they have stolen my whole concept. I have made a software which works the same. Right passive, left activa. The District Court of Hamburg has said that is all dictated by necessities and cannot be protected, because an accounting software always have activa and passiva. I had a case when I was a Court of Appeal judge in Düsseldorf. 5 nerds came to me and said, the software developing company UbiSoft has stolen our design. We have made a program with a computer game on steam engine and railway stations. And we have created a scene, a railway station with a tree and standing in front of it. There's the engine, there's steam coming out of the engine. And Professor, please help us. UbiSoft has done the same. They have a steam engine, they have a railway station, a tree standing in front of the railway station. I said, this is all dictated by necessities, because we have typically in a railway environment, a railway station, and a tree standing there, so it cannot be protected. That's a famous discussion in the United States, because in the United States, there's a new case, Oracle versus Google. Oracle is the right owner for Java, and Google has made an API, a small program for smartphones. So it was based on the technical structure of Java. So Oracle had these neuroscience in their eyes and said, we want to have money from Google. It took the Supreme Court more than 10 years to decide that the API, this small program of Java, is protected by copyright law, but it's not protected against Google because that's fair use. So we say in Europe, if somebody is stealing the software functionalities like an API, the API is not protected by copyright law. In the United States, we say it is protected, but in order to get copy the structure is fair use, is free. So, mm, mm. Next thing, so the protection is only there for the form of a program that's mentioned in Article 1, subsection 2. Protection shall apply to the expression in any form of a computer program. If you want to know what is computer program, you don't find any definition. So one day I've made a decision as a Court of Appeal judge to ask an expert whether a specific technical system is a software, is computer program. And he said, how do I know whether software is software? I said, we don't have a definition. Nobody knows. The WIPO has made a definition, but that has not been used in this directive. So the expert needed 10 years to distinguish what is software and what is not software in a technical program. So every form of expression, that means source code and machine code. You never heard the words before, but this is very important to understand. Think of source code. That's the way modern programmers are programming, and that is what the machine does. Let me start with the machine. The machine is a stupid tool. A computer is totally rubbish because it simply plugs on electricity, that's one, and stops electricity, that's zero. That's all. That is digital society. A machine which simply is set on, off, and that very quickly. That's called machine code. You see here only sign saying 0, 0, 0, 1, 0. That means remain silent, plug on, and so on. Nobody can make programs like that. I knew several guys who made it 30 years ago, but today a programmer is programming like that. You see, although you are not an expert, so you can, to a certain extent, understand what is mentioned here. So, problem is, you need to translate that in machine code. Machine can only understand machine code. That's called compilation. translation of source code into object code. The customer of a software house only gets that machine code. He never gets normally the source code. So the dream of a customer would always be to decompile. So to retranslate the machine code to that code. Because then he can make changes in the code, but being let alone with machine code leads to a catastrophe. That's a typical problem in the IT industry. So when the Commission says in Article 1, subsection 2, protection shall apply to the expression in any form of a computer program, it simply means in source code and in object machine code. So even the design material shall be protected. That's mentioned in the preamble. So let me start with the standard of creativity. How much creativity should be in a program? You see Article 1, subsection 3. A computer program shall be protected if it is original in the sense that it's the author's own intellectual creation. So own intellectual creation means persönlich geistige Schöpfung within the German words. So it's a very old standard, but the question is, what does that mean? Is it high creativity, low? There's one helping word in the second sentence. No other criteria shall be applied to determine its eligibility for the protection. No other, we said in Germany, we don't apply any other criteria, but we need to interpret own intellectual creation. Only when you see the preamble, the recitals, you get a remark saying no other qualitative criteria. So every evaluation of the quality of software is not allowed. So even if a software is not very creative, it is protected by copyright. And imagine what it means. 70 years of the death of the author. Every short sentence, quick basic, go to that, mark that, is protected for a period of 70 years of the death of the author. It's far too long. Nobody needs that. But that has been given to the programming industry. They have a feeling, of course, of New Europe. We never say in old Europe, no qualitative criteria, every simple software needs to be protected. So it's a reference, a bow to the principle of sweat on the eyebrow. Have you ever met a programmer? He is not creative, but he is sweating like hell. So for this sweat, he gets 70 years of the death protection. So, and again, you see another element, Article 2, paragraph 3. Where a computer program is created by an employee in the execution of his duties, the employer shall exclusively be entitled to exercise all economic works in the program so created. the investor, the employer, gets all the economic rights. Another reference to United Kingdom. So that means the employer has all the economic rights in a program. It sounds like helping a lot for software industry, but asking the people here, have you ever seen Hiltrup? You know what Hiltrup is? Hiltrup is a very ugly suburb of Münster. And in Münster, we have in Hiltrup, we have the police academy, a big university for policemen. And in Hiltrup was a starting point for a case testing Article 2. There were two policemen who are writing a book on their experiences in taking a rope and binding people. That book was a huge success. It was sold everywhere, but unfortunately in the area which a policeman didn't know. Imagine yourself who's using that book. So the police academy said, we are the right holder. And they applied that principle of Article 2(3) and said, is a computer program created in the execution of the duties? No. They were teachers at the police academy, but they didn't make this book in the execution of the duties. Or are they following the instructions given by the employer? No. They are simply writing down their experiences, which they have in tying other people. So the court in Germany said, in dubio pro auctora, that is free for the policemen to use. They get the money. So then Article 4. That are all the restricted economic rights given to the employer. So you see here, the exclusive rights shall include first the the permanent or temporary reproduction of computer program. So very important is the reproduction right. So nobody is allowed to make any copy. So one of the big issues in the AI that is coming again is the question, what does temporary reproduction mean? Because sometimes a computer program is not copied permanently. Of course, making a copy on CD, DVD is of course part of the right giving to the right holder. But sometimes it's only stored on the RAM. Have you ever heard about RAM? What does it mean? It's not a Buddhist sect. RAM, ever heard? Random access memory. It means on a temporary storage device, the working memory of a computer. It's only there, a copy, so long as you have electricity and you don't change the system. Is a copy on a RAM, is that a copy within the sense of the Copyright Act? I have given you one new decision of the ECJ of last Friday. You remember? It was called action replay, and it has to do with cheat software. And there is somebody of you a gamer? No gamer here? He looks like a gamer, but he is not a gamer. So, if you play on a console of Sony, you're playing a lot of computer games, and there are some bad guys who sell cheat software which allows you to be the hero per se. You get the most top level of the game. Very important. I hate to play it 13 hours on a console. I want to be always the first, the best from the starting point. And that is solved by cheat software. All what a cheat software does, it makes a copy in the RAM and then changes the data foreseen by Sony. And you get the best data in the system. It's very, very popular. Of course, Sony was not very nice and said, we want to prohibit any cheat software. The cheat software, but it makes no permanent copy of the software. It changes the storage of software on a RAM-based level. The Federal Supreme Court in Germany said, so we are very unsure, we don't want to make mistakes, so we asked the ECJ for help. And they ask a very bad question. They ask, is that software within Article 1? They didn't ask whether it's Article 4. So they only ask, is it as a question for software protection in the sense of Article 1? The ECJ says if they're asking nasty questions, it's not our task to say what the real question is. We answer no, because a storage in a memory of data apart from the original program has nothing to do with software protection at all. So that's a new case. And then think of the changes which are made using ChatGPT and others. All these changes in the data structure in a RAM are no changes within copyright law. Very important, in my view, a very important decision which you should read at home unless you have read it already. So, yeah, there you see the typical stupid questions of the German Federal Supreme Court. Second act restricted for the right holder is translation, adaptation, and alteration of a computer program. For instance, if the Federal Supreme Court would have asked, is that an alteration of a computer program to use cheat software, that the case would be would have had a much more impact, but the German question was very bad. So then the third right, Article 4.3, the distribution right. Distribution does mean you are selling or making available physical copies to other persons. That is foreseen as an exclusive right for the right holder. For instance, reselling, exchanging, renting, giving away software. But we have one problem. We have the exhaustion principle mentioned in Article 4, subsection 3. The first thing, why should I read it? Perhaps you can read it. 4.3. Four. And then to two, so sorry. Okay.
State the copy of program by the right holder of this consent shall exhaust the distribution right within the community of that copy, with the exception of the right to control further rental of the program or a copy.
Yeah, that's a famous exhaustion principle, which has nothing to do with a state which you are in after 1 hour of lecture. It means if you have first sale, start with first sale in the community. When you have first sold your copy in the community, the further distribution right is exhausted, is away. So that means a freedom to resell, for instance, used software. So can we have a second market for used software? Yes or no? And I'm happy to say on the 3rd of July 2012, I was running around as a dean of the faculty, naked, and said, yes, because I always said in my doctoral thesis, the first sale doctrine applies to software. And nobody was believing me. They all said, Thomas Hoeren is stupid. And at the 3rd of July 2012, the court said, European Court of Justice said, Thomas is right. Unfortunately, they didn't mention me, but it was right. So they applied the principle of exhaustion to software. So you can today sell used software or buy used software, but only 7 years later, the European Court of Justice said the contrary. Not for software, they said it's okay for software, exhaustion doctrine, but for e-books, that doesn't apply. So you can not resell e-books to another person. Have you ever bought an e-book for Amazon Kindle or others? Sometimes they are really expensive. So why doesn't there exist a market where you can buy a used e-book? The European Court of Justice said, no, that's not software. This has nothing to do with software. So that's not possible. And then we have, let us see, the forthright communication to the public. If you're distributing software on the internet, that can only be done if the internet is public, accessible to members of the public from places and at times of their choosing. So, take for instance the use of software within a local area network, so not public, that is not governed by an exclusive right of right holder. So, barriers. You see, Article 5, and I hate to the utmost the title of Article 5 has mentioned exceptions. It's not an exception, it's a barrier, it's an exemption. So exceptions are interpreted traditionally narrowly. So if you would re-accept this word, exception in Article 5, all the exceptions have to interpret it narrowly. That's not true. There are limitations which gives a right of information back, the freedom of information back to the public. So, take for instance, Article 6 is important in Article 5, 2 and 3. So, Article 5 said that the user can do what he wants if it is necessary for the use of the computer program, including for error correction. So the user has a right to do what he wants in order to make the software work. So that's important. So you see another mistake in the directive. It started with in the absence of specific contractual provisions. Of course, software industry said, oh, we can simply say no. We will write in the contract, you are not allowed to do what is mentioned in Article 5, subsection 1. But in the preamble, it said this right is mandatory. So how does a preamble which says it is mandatory fit with a text for saying in the absence of the specific contractual provisions? The Federal Supreme Court in Germany said the solution might be the word specific. So simply saying no is not possible. But you can say, I am providing for specific services, and these services are including the right of self-error provision. So then freedom to make backup copies at Article 5, subsection 2, and freedom to make testing. There's always a very bad exemption, because does anybody of you know hackers? You have a friend who's a hacker? Or why not? They're nice, charming people. So there are some hackers running around in the Faculty of Informations, and for instance, Volkswagen is asking for the help. We call it penetration tests. They're taking hackers into Volkswagen and say, check the security of our organization. If you manage to penetrate our service, then we have a problem. And we need to know the problems internally before the public is discussing it. Is the involvement of third-party hackers, is it allowed or not? Article 5, subsection 3 only gives testing rights to the person who has a use right. So third-party hacking penetration is not allowed. So then Article 6, decompilation. When the German act on that directive was discussed in Parliament, our Chancellor Kohl said, I don't want that act to be entered into force because I don't understand what is decompilation. Now you know what is decompilation. What is decompilation? What has this strange law professor told you 30 minutes ago? That is computation. But you almost got it. What is decompilation? Yeah, it's the retranslation of machine code into source code. The dream of the user who only has a machine code and who wants to press PUM and then get the original source code. Of course, that's very dangerous for the software industry. And therefore, we have made a long exemption in Article 6. Most important is the word, it's possible to achieve the interoperability of an independently created computer program. I don't want to tell you what that is. Nobody knows today what is mentioned with that. But in 2021, the European Court of Justice made a remarkable decision and said, does the freedom to decompile, mentioned in Article 6, applies also in cases of Article 5.1. That means that decompile can be made for the use of the computer program by the lawful acquirer. And that's what they said. Article 5, subject 1, has to be read within Article 6, and you can decompile for doing, for instance, error correction mentioned in Article 5. So now, of course, the user can retranslate the source code. However, it's still a technical problem. In order to retranslate, you never get the original source code. If you have a friend, you have to talk to him this afternoon. If he is an informatic guy, and he will tell you all your commentary lines of the original source code are lost if you translate source into machine code. So the dream of having the original source code doesn't work, but at least is a help in order to understand. So now I have 50 minutes for the second directive. Oh. So are you all awake? Everybody listening? Mr. Gramlich looks very sad and angry, but I'm sorry for that. It's a typical topic. Okay. Let me quickly go to the second directive. That's the famous database right. That was years later in 1996, the Commission made a second directive. Here of a structure, what I want to say, you see 83 slides in 50 minutes. It's nearly impossible, but I will try to make it. What the Commission said, we need a separate concept of protecting digital products. That is a database right. And in Article 3 and Article 7, they made a two-tier database work and database protection. Article 3, database work, that is a copyright in the narrow sense. So a copyright protection for works which are really copyrightable databases. So that's a reference to France, to old Europe. But then they said we need to have a twofold protection of databases as well. In Article 7, they invented a sui generis protection for databases. And you see here, that's based on significant investment in procuring, review, and presentation. If you hear investment within copyright law, you have already in your mind New Europe. That is British. So they had a system combining old Europe with New Europe. Database and database-wide work are distinguished. Database work is based on own intellectual creation. Database on the investment in collecting and arranging data or other works. Why have they made it? Just to explain that, they've made it because in 1996, Chinese people were used by European companies to retyping the telephone directory of London. So thousands of Chinese were sitting in Shanghai and typing the telephone directory of London. Why are they doing it? Because then you can sell CDs or DVDs with a telephone directory and nobody needs any book and so on. It's a very huge market. But you see the problem, that it cannot be called a database work because it's not based on creativity. It's A to Z, so not very much creation. But you can say there's a lot of investment in collecting these data, and that is protected separately. So, substantial investment is a test. When I want to skip some of the slides. Historical questions. We had, before the directive, certain national rules. For instance, the sweat of the eyebrow copyright in the UK, because it's very, very much work, a lot of sweat on the eyebrow if you're typing the whole telephone directory of London. So the British would say, of course, protected. We say in old Europe, no. We have a catalog protection, separate protection of catalog in Scandinavia, and we had a separate regime invented by the Hoge Raad in the Netherlands, the so-called Geschriftenbescherming. So that was a background for making this directive. There was a need for harmonizing these existing regimes. So to say that the person who has drafted the directive was a person who was total hater of the United States. He was in full hate of the United States. Jens Gasser, he, by the way, drafted the first slides, because now I'm used some of the slides of Jens Gasser, a close friend of mine. but he was a really high representative of the European Commission, strongly fighting against the US. He said, we don't want US databases to be protected under this system. So no non-EU countries do get that protection on the basis of reciprocity. Perhaps you remember I said the RBC, the Rice-Berne Convention, prohibits reciprocity, but therefore he said, I will use database, not base database works as the basis for the directive. So the US databases are not protected by the European rules. Also, the databases from Switzerland, not a new non-EU country, they are not protected by that directive. So I skip that. You only need two elements. One is a database, and you see the broad term of database, a collection of works, data, or other independent elements. So that's very broad, even in the sense of AI Act, in the sense of Data Act. And the second requirement is significant investment. You have to prove that you have taken time, costs, and money in order to collect data. And then you get this sui generis right. For instance, for a road atlas, for a stamp collection, all that can be database. So let me finish by mentioning a very interesting case that was cleared a lot of. There's a European Court of Justice in William Hill against British Horse Racing Board. William Hill wanted to get access to the database of the British Horse Racing Agency, very important in England. But the British Horse Racing Agency said, no, we don't want, but the European Court of Justice decided. Is the British Horse Racing database protected? That means, is it a database? Yes. Does it have substantial investment? And then the court said quite clear, only the cost for the collection and search for existing data is protected, not the cost for the data as such. So simply to know which horse was winning at an escort race, that's not protected. So it's not only protected the way the data are structured, collected, that is protected, but simply to type down all these horses winning an actual escort doesn't involve substantial investment. So British Horse Racing Board lost the case, as a matter of fact. So that's all for now. Simply wait. I will stop Freigabe. So unfortunately, I cannot do all slides. Perhaps I will finish my slides in 2 weeks. Next week, Guido Westkamp will talk about further elements, common features of European copyright law, which are important for AI, electronic data, and so on. So today we are finished. Please join us also next Tuesday at 11:30 in the Q&A session. So a question here? That will take place here, but you don't need to wait. So if you are not interested, you simply go out. Everything fine. See you then.
Thank you, sir. Bye-bye.
Dankeschön.
Goodbye.
Thank you. Goodbye.